All right, so welcome everybody. My name is Roger Berkowitz. I'm the founder and academic director here at the Hannah Arendt Center at Bard College. Pleased to be with you today for the virtual reading group. If you'll notice, Yana Mater is not here today, and one of our Arendt Center fellows, Alex Vitanov, is here. He'll be moderating today. If you have any issues or questions, he's the one you should approach under the Hannah Arendt Center name. Thank you, Alex, for being here. So today we're continuing to read Hannah Arendt's Eichmann in Jerusalem. We're actually reading what is, in some sense, the final chapter. Although it's not, because after today we still have the epilogue, and then the postscript, and then we're going to read also some excerpts of Bettina Stangneth's book Eichmann Before Jerusalem, about Eichmann's time in Argentina and his interviews with Colonel Willem Sasson, who we'll talk a little bit about today as well. So the epilogue, which will come next week, is really the final chapter, although it's the epilogue, and it's where Arendt draws a lot of her main conclusions about the trial. The postscript was written a few years later after the controversy, after so many people loved the book and attacked the book, and it's her attempt to respond in some way to those controversies. But when I say this is the final chapter, chapter 15, Judgment, Appeal, and Execution, what I mean is it's the last factual chapter, right? One of the claims that Arendt makes throughout the book and in her response to critics as well is that this was a report, right? A report on the banality of evil was the title she gave it. She thinks of it as a factual report. And insofar as it's a factual report, she doesn't believe that she's giving too much of her opinion or judgments. It's much more trying to report on the trial like a journalist would. And she really does go out of her way to make it quite a bit of reportage and quite factual. And so if in the last chapter, chapter 14, we were talking about the evidence and witnesses, right? Who were the witnesses? What was the evidence that was brought forth at the trial? We're now looking at the end of the trial, the judgment given by the district court, or not the district court, the lower court, and then the appeal, and then the execution. Now, having said all that, the chapter starts a bit strangely, I think, if you're looking for that, starting with the judgment, because it starts with Eichmann cooling his heels in Berlin at the end of the war, and what he's doing as the war is ending and the Nazis are losing. He tries to create a battalion to go and fight in the mountains. That doesn't work, and eventually he's arrested at the end of the war, held in an American camp for SS men, but even though he was held there, they did not know his identity, and he let it be known he was dead. The Nuremberg trials happen, and Eichmann's name is mentioned, and people think he's dead or disappeared. They don't know where he is. He escapes this camp eventually and goes to work as a lumberjack, and then after 4 years, he's helped by a clandestine SS veteran organization called Odessa to get to Italy, where a Franciscan priest who knows who he is and what he's done gives him papers and identities and sends him to Buenos Aires under the pseudonym Ricardo Clement. He's able to contact his wife, and his family joins him. He gets a job at a Mercedes-Benz factory. He has a 4th child named Ricardo Francisco Clement Eichmann. All of which, and one wonders, or I wonder, maybe some of you wonder, why is this here? Why is Arendt telling this part of the story here? Well, partly it's the last chapter, and she's telling the last chapter of Eichmann's career, so to say, in the Nazi world. And it's the post-war career. But it's also because she's at least suggesting in some of these facts, and also in the way she presents them, that he wasn't really hiding very well, that he sort of almost wanted to be caught, right? He names his fourth child, who's born while he's in Argentina, Ricardo Francesco Clement Eichmann. Not exactly something you do if you don't want to be found. He's leading a dreary and poor life, she says, and his only compensation was talking endlessly with the other Nazis, all of whom knew who he was and respected him in that way because he was someone who was involved with the final solution. In 1955, he begins a series of interviews with this Dutch journalist, Willem Sassen, who I mentioned earlier, who was a former armed SS and had been condemned to death in absentia in Belgium. Eichmann, for these interviews, took copious notes to prepare for the interviews, and these notes were discovered and admitted as evidence at trial. So Arendt had access to these notes that Eichmann took in preparation for the interviews with Sassen. The interviews were recorded, and then they were rewritten by Sassen with embellishments. Now, these recordings were not admitted and were largely not known the whereabouts of until about 10 years ago, when Bettina Stangneth found them and used them to prepare her book, Eichmann Before Jerusalem, which we'll read some excerpts of in a few weeks. And Arendt did not have access to those recordings. The fourth thing that she says is that Sassen then wrote up articles based on these interviews, and that these appeared first in German in Der Stern, a weekly magazine, and then in Life magazine in November and December. Her point is that Eichmann made many efforts to break his anonymity, and yet, for whatever reason, it still took Israel until 1959 to find him, at which point they kidnapped him with the Israeli Secret Service. This was a breach of international law, but Israel and Argentina both announced that they were not going to make a big deal of it, and they signed an agreement settling the matter. Eichmann was an Argentinian citizen, was not an Argentinian citizen, so there wasn't a real issue of Argentina being worried that one of their citizens had been kidnapped. He was still a German citizen, but the Germans were not going to insist on extraditing him. And so she says he was de facto stateless, which is what enabled the court in Israel to accept the fact that he'd been kidnapped illegally and try him anyway. But beyond that, he signed a statement in which he said that he would agree to be kidnapped, agreed to be taken to Israel and stand trial. And this is where, this is what all this sort of preliminary history has been leading up to, I think, in Arendt's account, which is that on page 242, she asks the question, why did Eichmann cooperate with the trial authorities, right? What was this about, right? He could have shut up. He could have tried to escape. He could have refused to go to Israel. Why did he go? Why did he then spend months dictating his autobiography to the Israeli captain who interviewed him for months, Abner Less, and why did he cooperate? And she says, the judges generally didn't believe him on things, but they asked him this question because they were interested in it too. They wanted to know, and he offered two answers. One was he was simply tired of being anonymous, right? And this goes to one of Arendt's repeated insights about Eichmann, that he wanted to be known, he wanted to be famous, he wanted to be recognized, that he needed that recognition. And so he was simply tired of the anonymity. He actually looked forward to a trial because he thought it would be like a big trial, a monstrous trial, as he put it, and that he thought it would give him a lot of attention. The second was that he says he heard that the youth in Germany were feeling guilty, and he said that he was upset about this because they had no reason to be guilty. It was the fault of his generation, he says, and he wanted to take on the burden of the guilt, and so relieve the guilt of the youth in Germany. Arendt says on 243 that, of course, all this was empty talk. He could have returned to Germany and given himself up or to Israel at any time when he was in Argentina, and he didn't. So we have to be somewhat skeptical of his reasons. But she also says on the same page, 243, that there was some truth behind the empty talk. He really did think that the trial would, in a sense, allow him to tell his story, and he wanted to tell his story. I mean, I think this is something that really comes out in Bettina Stangneth's book, Eichmann Before Jerusalem, which we'll read. Eichmann desperately wanted to tell his story. Whether he should have wanted to it, or whether he told the truthful story is a question that people have, but he wanted to tell it. And that's why Arendt thinks he cooperated so fully. All right. That's sort of the preliminaries. Now we get to the facts of the judgment, the trial and the judgment. There were 10 weeks in which the prosecution presented its case from April 11th to June 29th, 1961. Then from July 1st to August 14th, the defense, Eichmann's defense, Dr. Servatius, presented their defense. The court adjourned and then returned on December 11th to pronounce judgment on December 11th. For 2 days straight in 5 sessions, they read the judgment. It was long. And the judgment dropped one charge, namely the charge of conspiracy, which would have made him a chief war criminal. So the court did not accept the claim that he was part of the conspiracy to carry out the final solution. But they did convict Eichmann on all 15 other counts. Although there were some particulars that he was acquitted on. But the 15 counts were that 1 through 5 were crimes against the Jewish people. And the court made a caveat here, though, because these crimes they wanted to say were done with the intent to destroy the Jewish people. And so they said that Eichmann is only guilty of crimes against the Jewish people with the intent to destroy the Jewish people. So that's the equivalent of what today international law would call genocide, which is the crime against a people or an ethnicity or a religion with the intent to destroy in whole or in part that people. That he's only guilty of this for things he did after August 1941, which is when he was at the Wannsee conference and learned about the final solution. So according to the court, before August 1941, everything he did was not a crime against the Jewish people with the intent to destroy the Jewish people. Count 1 was causing the killing of millions of Jews. 2 was placing millions of Jews under conditions likely to lead to physical destruction. 3 was causing serious bodily mental harm to Jews. And 4 was directing that births be banned and pregnancies interrupted in Theresienstadt. With the one camp that he actually had some authority over. So those were the first 4 charges. Counts 5 through 12 dealt with crimes against humanity. And here there's a sort of a quirk of the Israeli trial, because crimes against humanity includes genocide against non-Jews, but doesn't include genocide against the Jews, because that was covered in the crimes against the Jewish people. And Arendt wants to point this out because, and as she'll talk about later in the epilogue, that there's something in her mind wrong or strange, and I think in her mind wrong, about separating out the Jews from humanity. She thinks there's actually a weird mistake in that. But she doesn't talk about that here. She'll come back to that in the epilogue. And so these crimes against humanity cover everything Eichmann did prior to 1941 as a crime against humanity, as well as after 1941 against non-Jews. And that includes genocide against non-Jews in count 5, that he persecuted Jews on racial grounds and political grounds in count 6, that he plundered the property and linked with the murder of these Jews in count 7, that all these are war crimes, count 8, that he expelled the Poles from their homes in count 9, that he expelled the Slovenes from their homes in count 10, that he organized the deportation of gypsies to Auschwitz. Here, again, she criticizes the court insofar as the court says that there was no proof of intent, and therefore this was not a genocide, but simply a war crime. Arendt says that there was plenty of proof of intent, and in fact, Eichmann admitted that he sent the gypsies to Auschwitz knowing that they would be killed. But for some reason, well, not for some reason, in her mind, because the court wanted the only genocide that they recognized to be the genocide of the Jews, they found that there was not enough proof given that he had the intent to destroy the gypsies. Count 12 was the deportation of 93 children from Lidce, which is a Czech village. But he was acquitted in the particular attempt to argue that he participated in the murder of these children in some way. And she says he was rightly acquitted for that. The last 3 counts were minor counts or misdemeanors, that he was charged with membership in criminal organizations. The crimes of counts 1 through 12 all carried the death penalty. After the judges read the judgment, in reading the judgment, the big surprise, she says, is that the judges largely agreed with Eichmann on an important point. So on page 246, she says that Eichmann had claimed in his defense and in his autobiography and in his opening statement that he was guilty and that he knew he would be killed and he wanted to be killed as an example for what he had done. But he said that all he was guilty of was aiding and abetting in these crimes, right? So in law, some of you are lawyers, but for those who are not, we have a crime of murder, and then there's a crime of aiding and abetting murder, which is not actually killing someone, but sort of helping someone to carry out the killing. And so since Eichmann claimed, and the court believed him, that he had actually never killed anyone, he wanted to say, look, I never killed anyone. All I did was help organize deportations. And so all I could really be said to do was aid and abet with the killing. And surprisingly, Arendt says, the judges largely agreed with him. So she quotes from the judgment, and I'm going to read the relevant part on page 246. She says, the judgment, to one's great relief, in a way recognized that the prosecution had not succeeded in proving Eichmann wrong on this point. For it was an important point. It touched upon the very essence of this crime, which was no ordinary crime, and the very nature of this criminal, who was no common criminal, By implication, it also took cognizance of the weird fact that in the death camps, it was usually the inmates and the victims who had actually wielded the fatal instrument with their own hands. So, what the judgment said in its own words was this: expressing Eichmann's activities in terms of Section 23 of our Criminal Code Ordinance, we should say that they were mainly those of a person soliciting by giving counsel advice to others of one who enabled or aided others in the criminal act. So the court said that Eichmann's activities were not murder or genocide or crimes against humanity, but aiding and abetting murder and genocide and crimes against humanities. But then the judgment continues, and this is the most important part, and Arendt cites it at length. So I'm going to read it at length because I think it's important. The court says, but in such an enormous and complicated crime as the one we are now considering, wherein many people participated on various levels and various modes of activity. So in such a large, bureaucratic, institutionally organized crime, the court writes, the planners, the organizers, and those executing the deeds according to their various ranks, there is not much point in using the ordinary concepts of counseling and soliciting to commit a crime. In such a complicated crime with so many different bureaucratic agencies involved, using our typical legal idea of aiding and abetting doesn't make sense. The court continues, for these crimes were committed en masse, not only in regard to the number of victims, but also in regard to the numbers of those who perpetrated the crime, and the extent to which any one of the many criminals was close to or remote from the actual killer of the victims means nothing as far as the measure of his responsibility is concerned, right? So many people were involved in the Holocaust and the final solution that it really doesn't matter if you were the one wielding the axe or the one signing the order. And here's the last line, which is Arendt finds really important and italicizes, and I think she thinks is really right. The court says, on the contrary, in general, the degree of responsibility increases as we draw further away from the man who uses the final instrument, the fatal instrument, with his own hands. In general, the degree of responsibility increases as we draw further away from the man who uses the fatal instrument with his own hands. So the people signing the orders behind the desk are more responsible than the people pulling the trigger or turning on the gas in the showers. And so what the court says is, even though in some sense Eichmann is right, all he did was, under traditional law, aid and abet, in a crime like this, these distinctions don't matter. And in fact, the further you are from the actual act, the more you're just aiding and abetting. Mostly it means the more responsible you are. And this is the court's response to the problem that Eichmann was right in his sort of limited legal sense, that what he had done is aid and abet murder and genocide, not committed. And thus they impose the death penalty. Eichmann then issues his own statement where he says, quote, this is on 247, his hopes for justice were disappointed. The court had not believed him, though he'd always done his best to tell the truth. The court did not understand him. He had never been a Jew hater. He had never willed the murder of human beings. His guilt came from his obedience, and obedience is praised as a virtue. His virtue had been abused by Nazi leaders. And he adds, I am not the monster I am made out to be. Arendt is here presenting his statement. The court doesn't do much with it. And on December 15th, 1961, the court issues the death sentence. Eichmann appeals, and the appellate court spends only a week. And on March 29th, May 29th, 1962, the appellate court judgment is read. It's 51 pages. And it's important, she says, because the appellate court actually changes the ruling of the lower court, right? It doesn't just affirm it, it changes it. It finds that the appellant, Eichmann, had received no superior orders in matters that concern Jewish matters, right? So it goes against the lower court, which found that he had taken orders and received orders. It also, the appellate court also found that he had eclipsed in importance all his superiors, including Mueller. It found that he was the most important actor in carrying out the final solution, more important than even much higher up officials. Arendt just reports this here. She obviously, I think, disagrees with it. We know that, but she just reports it. And she writes, the idea of the final solution. She says that the appellate court judgments proceeds along the lines that the idea of the final solution would never have assumed the infernal forms of flayed skin and tortured flesh of millions of Jews without the fanatical zeal and unquenchable bloodthirst of Eichmann and his accomplices. This is, she says, the very language of the prosecution, which the appellate court has embraced. Eichmann, at the advice of his attorney, writes 4 handwritten pages pleading for mercy. Also, his wife and family do so. In addition, hundreds of letters come to the court pleading for mercy, including from the Central Conference of American Rabbis, which is a representative group of Reformed Jews in the United States, and from a number of professors at Hebrew University, led by Martin Buber. Arendt doesn't think much of Buber's arguments and says so. On May 31st, 1962, Eichmann was hung slightly before midnight. His body was cremated. His ashes were scattered in the Mediterranean. There were some protests, including by Martin Buber and others, who argued that they should not have committed not have done the death penalty, or that this could be counterproductive or other things. But in any case, he was hung. And then we get to the final page of the chapter, and thus the final page of the book before the epilogue. And this page is important, especially for the last sentence. But on this page, Arendt says, Adolf Eichmann went to the gallows with great dignity. He had asked for a bottle of red wine and had drunk half of it. He refused the help of a Protestant minister. She says that he walked calm and erect.
This thing is just...
He had his hands bound behind him. And she says that he refuses a hood. She says he was completely himself, right? And then he says, I'm not a Christian, I'm a Gottgläubiger. And then he says, gentlemen, we shall all meet again. Such is the fate of all men. Long live Germany, long live Argentina, long live Austria. I shall not forget them. Arendt finds this laughable, I think is the right word. She says, in the face of death, he had found the cliche used in funeral oratory. Under the gallows, his memory played him the last trick. He was elated and forgot this was his own funeral. And this is part of her general sense that he just speaks in cliches and can't think. And then comes the final sentence of the book, the only time in the whole book that the word banality is used, in which she writes, it was as though in those last minutes, he was summing up the lesson that this long course in human wickedness had taught us. The lesson of the fearsome word and thought-defying banality of evil. Right? So this is the only time the word evil or banality are used, or banality of evil is used. And it's not just the banality of evil. And this is one thing that I'm going to sort of insist upon as we talk about it, and I'm hoping that you'll carry forward as a practice. Whenever people say, oh, the banality of evil, say, no, that's not what Arendt wrote. She wrote, "The fearsome word and thought defying banality of evil." That's what she's writing about. The argument here is that what Eichmann, in saying things like, "We will meet again, such is the fate of all men, long live Germany," in his cliches, in his need to be important, in his need to, in his willingness to do his duty and see his virtue in obedience, even if it means doing things he knows are wrong. All of this, she says, is the fearsome, we should be terrified of it, word and thought defying. It's a way in which evil is so banal that it defies words and thought. It makes words meaningless. It makes them cliches. It just becomes a kind of utter thoughtless conformity that flattens everything. And that's how she, as the only place in the text before she gets to the postscript where she's going to talk a lot about it and try and explain it. That's what she means by the banality of evil. Okay. I've already talked in other sessions a lot about some other ways to think about the banality of evil. I've told the story of an interview she does where she talks about these German prisoners of war, these Russian prisoners of war who are starving, and they're released, and they come out of prison and they start eating insects out of the dirt. And some German peasants are nearby and they say, "Oh, these are animals." And she's like, "That's what I mean by banality, right? An inability to see the world from the other perspective. These people are starving, and that as a starving person, you're going to eat anything you can, and that this is not meaning you're an animal. It just means that this is the reality you're in. And the banality of evil is the inability to think outside your own perspective. Word and thought defying. Thought defying is, for her, thinking means thinking from the perspective of the other, being able to get out of your own perspective and think from the perspective of other. That's what the banality of evil is. It doesn't allow you to do that. Okay, that's how she ends the book before the epilogue, and then there'll be a postscript. We'll end here. Again, feel free to engage in the conversation either through the chat or by raising your hand by going down to the reactions button at the bottom and clicking raise hand, and look forward to the conversation. Bernard.
Hi, I just a technical thing on the last posting, the last session that has been posted to YouTube, as near as I can tell, is the 9th session on deportations. And I had to miss a couple of sessions, and I'm just hoping I can catch up, and that the ones subsequent to that will still be posted to YouTube.
They will be posted. I'm sorry, it's the end of the semester. Some of our students who help us with these things have left. We're working on it. We're a small organization, and I thank you. I didn't know that, so thank you. I do know we're a little bit more caught up to date on the podcast, so you can always check it out on the podcast. But I apologize. It's taking a long time to get them up, and I hope they'll be up soon. I know they'll be up soon, so they'll come. Thanks, Bernard. Stephen.
Hi, Roger. Can you hear me?
I can.
Okay. I have two very critical comments with regard to this chapter. I'd like to present both, if you will allow that. So the first is on page 246, halfway down the page. Arendt, and you've read this, Arendt writes, quote, "In the death camps, it was usually the inmates and the victims who actually wielded," and she's quoting the judgment here, "the fatal instrument with," and she splices in, "their own hands," unquote. Well, this is false. The majority of the mass killing was due to gassing with Zyklon B, an extremely volatile poison compound used in pest control and fumigation. The gas was always administered by trained SS medical staff called the Hygiene and Disinfectant Detail. A doctor was present and canisters of pellets were poured by SS staff through vents on the roof of the gas chambers. There are several well-respected sources on this, including Raoul Hilberg's book, The Destruction of the European Jews, which Arendt used as a main source. So one wonders where she got her information.
Well, I mean, just to answer your question, and you answered it for yourself, Stephen, she got it from the judgment. That's what the judges said. So, you know, it was what the evidence at the trial presented. You know, what exactly they mean by it, or, you know, I don't know. But that's what the judges found in the judgment.
No. I think you've confused the quote with her writing. Do you see where she uses square brackets, their own hands? It's the man with man own hands. That's further down. Do you see that she's spliced that word there in?
Yeah, but that's
So her
that's
comment,
just to make it plural instead of singular.
okay, no, that's right. The inmates and the victims is her writing. That's not from the judgment.
Well, she's just paraphrasing the judgment and using quotes. I mean, so
No. Please go to the part one line up where it says it was usually the inmates and the victims who actually wielded. That's not in the judgment at all. I'm sorry, it's not. And I've been through this. I've spent a lot of time looking for where she might have gotten this idea that the inmates participated in the gassing of other inmates. It wasn't the Sonderkommando, because the Sonderkommando were allowed in after the people had been gassed. And this is very clear from the Holocaust literature.
all right, I'm just, you know, she's simply reporting what the judgment said. So, I mean, I don't know, you know, why the judgment put it in this way, and maybe they got it wrong.
No, because
all right, Stephen,
she's quoted.
Stephen, I hear what you're saying. You know, I mean, all I can say is this is what she's doing is reporting on the judgment.
Okay, let me continue then with my second criticism, which actually deals with the two quotes that you read at length. So again, on page 246, Arendt says that Eichmann insisted, quote, that he was guilty only of aiding and abetting in the commission of the crimes, that he himself had never committed an overt act, unquote. She suggests that the court, and this is, quote, her language, in a way, unquote, agreed. She says two separate quotes from the judgment she draws two separate quotes from the judgment to support her position. Those are the quotes that you read. However, she omits two qualifying statements from the judgment, which I looked up. The statements are, and they're a bridge between the two quotes, which she left out. And I'm going to read this quote. This is from the judgment. But we wish to emphasize that in any case, the accused is regarded as committing the crime itself, according to the opening part of section 23. Now, section 23, I also posted the actual law from the Criminal Code Ordinance of 1936, which was the law used in the court.
Yeah, she agrees with that. She agrees with that. I agree with that.
Okay, so let's understand that section 23 of the Criminal Code Ordinance 1936, which is all about, and this is in the language, which is all about defining principal offenders. The court found that Eichmann was a principal offender under the law.
Of course. That's the point.
And so it's not like it's a lower crime.
No, Stephen, that's the whole point. You've misunderstood what she's saying and what I've said. I'm sorry. She's arguing that it's not a lower crime. In fact, that you're more responsible the further you're away from it. And
so
that's the point.
If you allow me, the second omission was the end of the last sentence that she italicized of the second quote on page 247. she actually edited that sentence. And I'm going to read the complete sentence and with the part that she omitted, so it's very clear that Eichmann was a counselor. Quote, on the contrary, in general, the degree of responsibility increases as we draw further away from the man who uses the fatal instrument with his own hands and reach the higher ranks of command, the counselors in the language of our law. We just heard that Eichmann, according to the law, was a counselor. So the court is clearly placing Eichmann in that higher echelon of superiors who ordered the final solution. This is really important to understand the
Of
court's
course,
position.
but that's the point.
It's not a lower crime. If you look at section 20.
Even nobody said it's a lower crime. I mean, I don't understand how you're trying to read this as if she's saying it's a lower crime, which is the exact opposite of what she's saying.
I'm saying that she okay, when including these omissions, it's clear that the prosecution proved that Eichmann as a principal offender carries full guilt and that he committed an overt act, inasmuch as had he not acted in the manner in which he did, the crimes would not have taken place. I think we need to understand that her use of this phrase, overt act, is actually what the court would determine as an offense of a principal offender. The crimes would not have happened had he not acted in the way that he acted. I think it's very important to understand that how she frames the judgment and what the judgment is saying, and she omits these parts out, actually undermines this claim of that all he did was aid and abet.
Yeah. So I think you've completely misread the book. And, that's all I can say is she doesn't say that all Eichmann did is aid and abet. In fact, her argument is the opposite of that, right? Her argument is that under traditional legal principles, that's what he said he did. And the judges sort of agreed on traditional legal principles, but that in a case like this, you can't proceed under traditional legal principles. And you have to understand that the people who are the counselors and abettors are actually more responsible than the people who turn the valves or shot or pulled the trigger. And so she's agreeing with the court on that. And
Roger,
yeah.
Do you see that Eichmann is a counselor? Do you agree with that?
I'm happy to say he's a counselor in the way you're using it. I mean, I don't think that's what his official role was, but you're trying to play a lawyer here. I'm trying to say she and I agree with the court here. You're trying to say she doesn't, and I think you're just misreading her.
Well, her quote was that he wasn't
all I can say, Stephen.
That he was guilty only of aiding and abetting. That's her.
That's not what she says. I don't know why you keep saying that.
He says that at the first part of the paragraph, sir.
She doesn't say that, sir. You're just wrong.
Eichmann,
you're misreading the text.
I'm quoting. Please help me here. Please explain. This is a quote from her halfway down the page. Eichmann, it will be remembered, had steadfastly insisted he was guilty only of aiding and abetting in the commission of the crimes with which he was
That's what he insisted.
Right. And she's taking that position.
No, well, Stephen, again, I don't know how many times to say it. Eichmann said that. The judgment in a way recognized, right, that the prosecution had not succeeded in proving him wrong. In a way recognized. But the judgment then went on and said, in that way, it doesn't matter because he actually, in this kind of a case, that way is irrelevant. And what matters is that he was guilty. And they were right.
But she left out this qualifying quote.
She didn't leave anything out of importance. I mean, honestly, I think this is one of those situations where you're so interested in playing the prosecutor to show that she did something wrong that you're just unwilling to accept the fact that she actually is saying what you agree with.
Can you explain to me then?
I've explained it a number of times.
No, but the quote, but we wish to emphasize that in any case, the accused is regarded as committing the crime itself. Can you explain that as not being a primary offender, a principal offender? Can you just, I mean, you're the lawyer, you say you're the lawyer.
I don't know what you're talking, I don't know where you're reading from.
It's from the judgment. What my
All right.
point, she's,
Just because she left that out doesn't, I mean, that's a very legalistic reading. Fine. What she's saying is he was guilty of the crime, and the judges understood it in that way. They were honest enough to say that under traditional legal principles, he would have been guilty of aiding and abetting, but we can't go by traditional legal principles. And that's what they say. And she thinks they're right. She thinks the appellate judges are wrong, but she thinks the lower court judges are right.
well, I'm not playing lawyer. I'm quoting the judgment. I'll leave it at that. I presented my two criticisms. I'm saying she surgically omitted two qualifying, and this is the very next sentence from her first quote, and it's a bridge statement. So in other words, it comes between the two quotes. I'm sorry that this challenges your understanding of it. I think she's.
Well, I mean, it's nothing challenged my understanding of it. It's just that you're not willing to read what she wrote. I don't think.
Well, I'm splicing in what I'm putting it into the context of the
I
judgment.
mean,
Why
okay.
can't,
You can't
otherwise-
just say that the judge, the judgment was like 100 pages. She shortened it,
no, it's 227. And
but there's no reason
227.
there's no reason to think, I mean, there's nothing she says in here which suggests that Eichmann was not guilty of the crime. In fact, it's the opposite.
But
But you're
you know,
trying to argue that she's saying that Eichmann never, and doesn't believe it.
are you not saying that the second quote is trying to distance Eichmann from
No,
the higher
not at all.
echelons? I thought the whole second quote was about the actual murderers and the higher echelons.
The second quote is about the fact that in crimes like this, the difference doesn't matter.
And that's the part where she admitted and reached the higher ranks of command, the counselors
Okay.
in the language
Well,
of
what
the
she
law.
says is the higher ranks of command are more guilty than the lower.
And he was a counselor.
And therefore
too.
he's more guilty. That's the point.
Yeah, the point is he's very, very guilty.
Yeah,
Okay,
that's her point. She's very, very guilty.
I'd really like to get into this further. I don't want to monopolize others. Others would like to talk, but I think we need to take these criticisms quite seriously, especially the one with regard to the gassing of the Jews.
All right,
The
thank you.
The inmates.
Thanks, Stephen. Jeff.
Thanks, Roger.
Oh boy, raising my hand after Stephen, I knew it was a risk, but really, this is a tough one now. My question was about the something that just occurred to me. I felt it throughout the whole thing, throughout the whole book, actually, and I think it's going to be mostly in the epilogue, which I haven't read. But the sense of humor that Arendt displays, which I love, and I think it comes from Nietzsche, and I'd love to hear thoughts about that, but I don't really have a pointed question about that. One of the examples that of that sense of humor also, and for some reason I don't have it marked in my thing, so I can't find the exact thing, and I wouldn't have the right page anyway, is that when she talks about the I don't know, I guess it's the Mossad or whatever, the police force that located Eichmann. He wasn't trying to hide, as you pointed out in your opening comments, and so why did it take them so long to find him? And it seems, reading just a little bit between the lines, it seems like they were waiting for the statute of limitations to run out in Germany so that he wouldn't be recalled to Germany. They wanted to make sure he was brought to Israel, and so as soon as that expired, then they got him. The sense of humor part works in because it's just all this. I guess the absurdity is really the best word, and the existentialism was definitely on the rise during this whole period. There's something. I wonder how much of the reaction to the book is really rooted in this thing, which we've just sort of had amply demonstrated here, that basically her willing to look at things as being absurd, and thus, as the saying goes, all we can do is laugh.
Yeah.
And so she does that, and I think she's getting called to task for that, which I don't think is fair, because I like Nietzsche, and all of her books have got elements of Nietzsche, but that would be a whole other lecture.
Thanks, Jeff. There's no doubt that the tone of the book is off-putting to many people, and to many of her closest friends. I mean, Jonas, Scholem, to name two, really found. I mean, Scholem, Gershom Scholem found the tone he called it a heimische tone, heimische, folksy kind of tone. Um, some people have called it ironic. Others just called it funny. You know, and I think you're right. It's there. And she says, I admit it. That I can't change. That's who I am. That's how I deal with this. But there's no doubt that that tone is hers. I think there's no doubt that Nietzsche has a similar tone in some of his writings. So you're right about that. And you know, there's some people who think that that's an inappropriate tone to address something like the Holocaust. And in the end, I don't think there's any right or wrong answer to that. I think that's a question of judgment that everyone has to make on their own. And not everyone has to like her book, as she would be the first to say. I don't think it makes her book, you know, anti-Semitic or wrong or a defense of Eichmann. It's just, it's a tone. You know, I think I've said this another time, but I've been listening to this in the car every once in a while, just sort of to, you know, hear it. And it's obviously not her reading it, it's a person reading it. But I find myself laughing out loud a lot. And that's her tone. And some people find that helpful and some people find that offensive. And there's not much you can do about it. You know, so yeah, I'll leave it at that, but I think you're right.
But about on that question of whether you think that the police force waited until the limitations right?
Yeah, I mean, if you know, she would not have known this, but I think it's since come out that in Germany there was someone will remember. There was a prosecutor in Germany, who was on this case for a long time. I'm blanking on his name, but someone's gonna tell me in the chat. In any case, he had sort of figured out some of the clues and had kept trying to tell people, and no one wanted to hear it, and no one wanted to listen. And I think, I don't know if we know this for sure, but I think he's the one who eventually tipped the Mossad off to it. In the end, God, nobody's told me the name of this guy. Fritz Bauer, right? I think that's who it was. Someone can check to see if I got that right. But yes, so I think that there's no doubt that she is fairly convinced that the Germans had no interest in finding Eichmann. So you're right. Jerry.
Roger, you are a legal scholar, and it's as a legal scholar that I ask you this question. I don't want to revisit that long diatribe we heard, but this idea that of a responsibility increasing with the distance from the crime, what does that say about the crime? What do you? This is really quite shocking when if you take it on its face, to say that the more distant one is from committing a crime, the guiltier one is. So my question is very simple. It's just, what kind of crime is that? What does that say about the crime?
It says that it's no ordinary crime, right? So again,
is it unprecedented?
Well, I don't know if it's on. I think this one was. I'm not sure if there's never been one like, you know, never one that also, but you know, in a legal format, we speak of something called the actus reus and the mens rea, right? The actus reus is the guilty act, and the mens rea is the guilty mind, or the
There's no mens rea here.
Yeah. And so the idea is that in order to commit a crime, you need both to have done the guilty act, right? And you have the guilty intent. Part of the problem here is that Eichmann's intent at least until 1941, right? And then even after 1941, the intent he had was simply to put people, organize deportations. Can you make the claim that his intent was greater than that and was actually to commit genocide? Well, the court said, yes, you can after 1941, right? You can make that claim because he knew of the final solution. But the act he did, right, was not genocide. It was, as it was being a counselor and an abettor and etc. But it would be an abomination, the court says, and she agrees, to say that as a result, he's less responsible than the people who simply, pulled the triggers and turn the levers. He's more responsible. And so, they say in this kind of a crime, you can't just you can't go with the typical actus reus, the guilty act approach. You have to expand the framework, and so that's what the court does. I think it's a fairly let's put it this way, it's a fairly brilliant legal move, right? She's going to argue in the epilogue that it was the wrong move. Not because she disagrees with it, right? I don't want to, we haven't all read the epilogue, so I don't want to go there too far, but she's going to argue in the epilogue that the reason the court had this trouble, that, got it into this trouble that Stephen was, upset about, and not totally unjustifiably so, because the court got caught up on these questions of aiding and abetting. And what she's going to argue in the epilogue is to say all this was silly, right? It's because you were trying to fit what Eichmann did into legal rules and legal language. And what he did was so much worse and so unprecedented that we should actually jettison the legal language and make what she calls an extra legal judgment. That's the argument that she'll make at the end of the epilogue, to say that to actually encompass the enormity of Eichmann's crimes, the judges should have said, look, to judge according to the law cannot do justice to the enormity of what Eichmann did. And we actually have to move beyond that and make a political or extra legal judgment. And that's what she does at the end of the epilogue. That's what I find to be the most fascinating move in the whole book, and we'll get there next week. But yeah, I think what the court is doing is struggling to figure out how to, within the law, find Eichmann guilty, because we all knew he's guilty, and they do it through this sort of sleight of hand that Stephen objected to. And again, Arendt accepts it to one degree, but in the next chapter, in the epilogue, she's going to say, look, we should have just thrown the whole law out and said what he did was abomination, and we should kill him for doing that. And I think there's something to be said for what she argues as well. But this is a very innovative legal argument here that they're making, and she just presents it. Okay. Does that answer your question, Jerry? I'm not sure I can make it more legal than that.
We're getting there.
Getting there. Okay. Thank you, Jerry. George.
Okay, a couple of questions. First of all, speaking of this lengthy argument here, let me ask you, I'm not a lawyer, but it's just a question. If they had a RICO statue at that time, that would have been the end of it, wouldn't it?
Yeah, you got me, George. I don't know enough about the RICO statutes.
Well, the RICO statute is if there's a conspiracy
Right.
then everybody in the conspiracy is guilty. I mean, that's
Right,
what
but a part of the
they're
problem is
doing
that,
nowadays, and that's what they did with Gotti, and that's what they're trying to do nowadays. So I just want to leave it at that. But even if not, let me just go into another point. We're talking about, who's guilty. Again, if you're a ghetto or a concentration camp inmate about to be killed, let's say a concentration, you read, let's say you read a book rather than Eichmann in Jerusalem, you read Borowski's book about Let's Get to the Gas, ladies and gentlemen, and you see that the man who's standing in front of the cattle cars as the Jews are getting out is pointing the SS men. Some go to the right, and another one to the left, right to the left, right to the left. The ones that go to one side all get killed. How guilty is that man? So it's from the standpoint of the victims. I mean, this is a silly argument.
yeah,
It's just, on a silly technicality. And again, finally, what strikes me, I read someplace that, it's about somebody who studied Heidegger. Not so much that he was interested in Heidegger, but he was interested in Heideggerians. And this is also with I mean, how long can you argue about a little legal point and something like that in the face of Eichmann and the Holocaust and that whole business? It's one of the final things. I have a question for you. It sort of struck me. I don't know. I thought there was an original thought of mine, but I read it. I think Hannah Pithkin, whatever her name was, made it too. Is that one of the things that bothered Arendt so much about Eichmann is that he was a parvenu. He was a Nazi parvenu, and that really struck me as true. Maybe you want to speak about that.
thank you. Yeah, no, so, all good points. I mean, your first one I think is right. I mean, I think that's what Arendt's going to argue in the epilogue, which is what I was just talking to Jerry about, which is at some point arguing about legalities here is sort of silly, right? We all know he's guilty, say he's guilty and move on. And so, I think, what you're saying, I agree with, and I think Arendt fully agrees with. The it's always a tragedy when you think you have an original thought and then you read someone who's had it before you. Like that's, I think, in the American Scholar, Emerson says that's why you shouldn't read. But yes, I think you're right. Arendt had contempt for Eichmann as a parvenu, but also I think had contempt for him as simply a truly thoughtless, superficial man. And there's no doubt that contempt for him led her, colored very strongly the way she understood him in the trial. That's clear. Yeah. And to some degree, it led her to see him as less serious than some people want to see him, right? Not less responsible at all, but less serious. More banal, more superficial, less monstrous. That was her judgment of him.
Yeah, just finally to put a point on it, the opposite of the parvenu is the conscious pariah, and that's a sort of dramatic, heroic concept, and I think there's that aspect of her that I find enjoyable.
Yeah, well, I mean, that's what she tries to do, is to sort of remain a pariah, be conscious of it, and use that outsider status to look upon the world with fresh eyes, as she says. And that's what her role is. Is it possible she got Eichmann wrong and that Eichmann was not a parvenu, but a monster? Yeah, it's possible. And that's part of the argument, that people like Bettina Stangneth are going to have made, and that we'll talk about in a few weeks. And that certainly others have brought up over the last few weeks as we've been reading this. Making a judgment about anyone is difficult. to know that it's true or not. I mean, I'll tell the story when we do the Bettina Stangneth piece, but because I think Bettina Stangneth has a point. She could be right. Arendt could be right. The idea that someone can know that one of them is definitely right, I think, is impossible, right? How do we know whether Eichmann really was a monster or really was banal? I don't think we'll ever know that. And in some sense, her prejudices against him and where he came from and who he was had to have in some way influenced her judgment of him.
I think the people who got killed didn't care.
The people who got killed didn't care. I mean, and on that sense, there's no difference. She thinks he's a mass murderer and guilty, so, there you go. Vigdis.
Yes, a couple of questions. I just want to say that I totally agree with you on this about Eichmann, and no one can say exactly what he was or was not. It's always, I mean, then it has to be speculation. Anyone could be right, and it might have interesting points both ways. My question, first, I have one question that came up in the chat, Peggy Steckler asked, and it was quite interesting. I'm also curious about that. She asked who provided the subtitle to the book, a report on the banality of evil, because I think that's kind of makes me kind of curious to know if that was Arendt herself or if it's always publishers as well. And the other one is regarded the same as in a way also was pointed to. It was this about the degree of responsibility increases as we draw further away from the man who uses the fatal instrument with his own hands. And then it occurred to me, this court of appeal, when they kind of try to make him the kind of superior of orders, him to decide. Do you think that's a kind of way they wanted to make him more guilty according to existing laws? Because he was not just one who followed orders, and it would go against his statement that he was just an obedience praised a virtue as Eichmann himself saw it.
Yeah, I mean, so as for the subtitle, yeah, I think it was a publisher who recommended it, but I'm not sure the entire history of that, so I'll pass. Maybe somebody knows. Jerry might know that. I mean, one of the things that's worth taking seriously, along the lines of your question, is why Eichmann was so upset with the judgment, right? He says, I forget, let me find the actual quote, but after the judgment, Arendt paraphrases him in his statement, but he says, I am not the monster I am made out to be. And she says his hopes for justice were disappointed. The court had not believed him, though he'd always done his best to tell the truth. The court did not understand him. He had never been a Jew hater. He had never willed the murder of human beings, right? So, he wanted to say, I'm guilty, but not guilty in the sense of the indictment. And she says, what does he really mean by that? And we never really find out 100%. But I think, he thinks he's guilty, but not guilty of killing anyone, and not guilty of wanting to kill the Jews. And the court disagrees with him. Agrees with him that he's not guilty of actually with his hands killing anyone. But it says in this kind of a crime, that simply doesn't matter. You're more responsible for it than if you had done it with your hands. And that's where, I think Stephen's point is right, that that's what the court was saying. And I think Arendt agrees with it. And it's all, but the court also says that even though up until 1941, you hadn't had an intent to kill the Jews, after 1941, when you knew about the final solution, you can't say that what you were doing was not part of the extermination of the Jews. And so, you know, we simply, we find that you were guilty of acting and intending to kill the Jews. And that's where Eichmann, you know, didn't want to accept that. He didn't want to, he wanted to think all I did was, you know, organize trains and deportations. And I had nothing to do with the killing of the Jews. And the court just doesn't accept that view. They say he's guilty, and Arendt says he's guilty too. And that's something he was upset about. For Eichmann. Right.
I think it's incredibly important, this question of guilt and who is responsible and who is guilty, and not the least today with all that's going on, and who's really responsible. And it's always interesting to think about, and even maybe more today when we have the use of artificial intelligence and surveillance system used in warfare. I think the question of responsibility comes in new ways, and that's, I think it's so important to think about. So I look forward to read the epilogue. I haven't read it yet.
Well, I think you're going to enjoy it then. Okay. 845. I don't know who this is. It's 845.
It's Chris.
Oh, hi, Chris.
Hi, how are you doing? I just want to comment that a few things. When someone is ascribed to be an aider and abetter, they are no different than the person who pulls the trigger. The person who supplies the gun is no different. And what they're attempting to say in that on 247, the degree of responsibility increases as we draw further away from the man who uses the fatal instrument with his own hands. That, to me, raises the issue that they are, quote unquote, more guilty, in quotes, because without them providing the aid and abetting, the person who fires the weapon couldn't fire the weapon. And so it's really interesting. This whole trial was problematic. First of all, because none of the acts that occurred that caused the murder of millions of people took place in Israel. So the situs of the harm was not in Israel. Number two, the laws were retroactive as they were applied. And what you have here is this attempt to show that what Eichmann did, and take it from the time that he deals with the final solution, is that by providing the information and the ability to transport people to Auschwitz and Birkenau and all the other places is no different than the individuals who pulled the levers with regard to Zyklon B. And aiding and abetting has both a mens rea and an actus reus. The mens rea is the specific intent to commit the harm. And the harm here is the genocide. The actus reus is him setting up the schedules and enforcing that to get the people to the camps. So that what's going on in her book is a back and forth and not really dealing with the legal issues, and then the philosophical, cultural, and political issues that arise from this trial. And so I just wanted to make it clear, because there's massive misinformation and misunderstanding about conceptions of aiding and abetting. And
All
I
right,
can't
Chris, can I ask, Chris, I know you are a lawyer as well, so
I'm a former prosecutor who did aiding and abetting,
but my
and I'm also
understanding,
a defense lawyer.
my understanding is that, you know, I mean, I'm a former, I never practiced law, but I taught law, which is probably the worst thing you can do. But the crime of aiding and abetting, I don't know, let's say murder, comes with a much lower punishment than the crime of murder.
That
right?
depends on your jurisdiction.
Okay.
That depends on your jurisdiction.
But
in New York, there is no distinction. At least there wasn't when I was practicing in the Bronx assistant district attorney's office and then defending women who killed their batterers. I'm also a law professor, so I've taught criminal law, constitutional law, civil procedure, and I've practiced it.
Yeah.
And so for me, what you have here with this trial are nagging problems because it violated, because don't forget, this was not done under the Nuremberg laws. This was not. And so it raises a host of questions. But the concept of aiding and abetting is you are no different than the person who pulled the trigger. You gave them the gun and they pulled the trigger. You step into their shoes. Okay. So the distinction of principal and the counselor are interesting distinctions that are made, but it really does some violence to our conceptions of aiding and abetting. Now, you may not like aiding and abetting, and maybe it shouldn't be a theory.
That's helpful. I mean, I think I certainly agree with your overarching claim. And I think Arendt would as well, as far as I understand her, that the trial itself has many problems and she goes into them, although she, in the end ends having the trial. But, her refusal of the legal framework at the end, I think is constant with what you're saying. I think that in most jurisdictions and in my understanding, aiding and abetting is not the same as the crime itself, but it may be that in some jurisdictions it is, and I would stand corrected. I certainly taught it,
Roger, I don't
when I taught it
understand.
under criminal law. That's
I
how
don't understand your phrase when you say that aiding and abetting is not the crime itself.
Well,
When
there's a
aiding
crime,
and
aiding and abetting, but it's a different crime than murder. But anyway, I don't want to get caught up in too much. But I mean, we could, when you teach criminal law, there's separate crimes with separate actus reus and separate mens reas. But at least that's how we taught it. And unless I mistaught so many criminal lawyers over the years. And I have no doubt you know more about law than me. So I mean that honestly. So but that's how I understand it and I taught it. And so if I was wrong, I'm sorry to all my students. That's why I went and taught Arendt instead. But thank you, Chris. I appreciate it. John.
The book raises for me at a point that I struggle with, that I've touched on it about in the past about my experiences associated with Vietnam. But as we move more and more and as she does, from collective responsibility to individual responsibility on acts and of violence or criminal acts, and as our communication systems have vastly improved over the last 50 years, at what point do we suddenly, we may have collective knowledge to start with, but all of a sudden we now have individual knowledge? And at what point do we become responsible for acts that we know are wrong and we do nothing? And so I don't know. I don't know where the line goes. I'm not a lawyer. That was not my background. My background was finance. But it just seems to me this is one of the important aspects of this book, or at least for me, that you move at some point to this individual responsibility for acts that you're aware of. And at what point do you become responsible, and are you guilty for that?
Yes. That is what that's one of the things the book is about. So thank you, John. One way to think about it is the way the court does, which is to say that in crimes of this sort, responsibility grows the further away you get from the
Well,
actual.
no, that's not,
Um,
that's not where I'm trying to, the point I'm trying to make. The point I'm trying to make is that if that principle is correct, in today's world, where we, through the vast improvement of communications, we know, and we know instantly,
Yeah.
just about, where does our individual responsibility begin to emerge in today's environment?
So the point is that there's a difference between responsibility and guilt. This is a distinction Arendt makes in a number of places, writing largely after this book, but I think even somewhat before it as well, right? The word responsibility used in this particular text is about guilt, right? Your guilt increases the further you are away from the actual act or the killing act. But there are people who are not guilty, right? A German living in the countryside or even in Berlin doing their job who had nothing to do with either pulling the trigger or turning the wheel or deporting or anything. They were running their business. But many of them knew about it, at least some of them did. And they're not guilty, but are they responsible? At that point, responsibility is not a legal concept, right? You can't hold someone guilty for, not doing anything. I mean, there are these, in some jurisdictions, there's something called Good Samaritan laws, right? Where if you see somebody drowning and you don't help them, can you be prosecuted for not helping them? In most cases, the law has said no, because you don't have an affirmative duty to rescue or help. But that doesn't mean you don't have a responsibility to do something. And that responsibility is not legal. It's either social or political. And that's how Arendt tries to answer that question. It may be that people today, whether the question is Vietnam or institutional racism or a war in the Middle East, from whatever side one's on, that people who have no implication in it and thus are not guilty have a responsibility to engage in some political acts that reflect their political responsibilities. But that's not a legal question. And so I think that's the first step in trying to at least begin to think about and answer the question you've asked, John, which is an incredibly important one. And it does mean that we should not think that Germans who were just regular old Germans, or people who weren't even born yet, young Germans today, they're not guilty, right? There's no way that they're guilty. And that's why Arendt is so upset about the idea of collective guilt. But she says that doesn't necessarily mean that they don't have a collective responsibility as Germans to respond to their collective German past. And she thinks we can have an argument about what that responsibility is, but she doesn't find that argument, that discussion, to be problematic. In fact, she thinks that's essential, right? So we as Americans don't have guilt today about slavery. We had nothing to do with it. And she says to act guilty and to talk about white guilt for slavery, she says, is actually avoiding the problem, because it actually it stops us from asking the question, in her view, of who actually is guilty, who are doing things that are wrong. But to say that there's not guilt in that way doesn't mean that there's not responsibility, and doesn't mean that we can't then and shouldn't have a conversation about what our collective responsibility is to address historical wrongs and evils. And that's the way she frames that discussion. I hope that helps. I don't have a lot of time, but Dina, I'll give you 3 minutes.
Oh, I'm just wondering if one other distinction between Eichmann as the monster and Eichmann as the sort of illustrating the banality of evil is that the banality of evil, as Arendt says, is both word and thought defying. And then I want to emphasize the thought defying part, which suggests, I think, that the banality of evil is not a juridical subject, that Eichmann, as illustrating the banality of evil, is not beyond the law, but the law cannot conceive of it.
I think that's right. I think that part of her argument is that what Eichmann did explodes any attempt to capture it within legal categories, because it was so extraordinary.
Right. And whereas if you see him as a monster, we have categories for that.
Yeah, I think that's right. I think that's a good point. Yeah. Thank you. I accept that. Okay. Well, thank you.
Roger, can
Yeah.
I ask one question of, I'm dying to know what we're supposed to read of Bettina Stangneth.
Yeah, you're not the only one. I am, as you can tell, in a hotel, not at home, and I have been for a little while. We're gonna read largely the last chapter of her book. The reason we're reading that is that in that chapter, she provides extensive quotations from the tapes. And I figured I wanted us to have as much of the primary source of Eichmann speaking as possible. What I have not yet done is had a chance to photocopy those pages and load them up and get them to you. But if you have the book, we'll read the last chapter of the book Eichmann Before Jerusalem by Bettina Stangneth. But that's not for a couple of weeks. Next week we read the epilogue, and then we take 2 weeks off, and then we'll come back to the postscript and the Von Stangneth. So we actually have about a month. So we'll get it to you. And I apologize it's
So much.
so long. Thank you all very much. See you next week for the epilogue. Enjoy reading Hannah Arendt. Take care.
Thanks, everyone.
Ciao. Roger.
Ciao, ciao. Thank you very much.
Thanks, everyone.
Thank you.
Thank you. Bye-bye.
Thank you.
Thank you.
Gracias.